it's Aprilia and welcome back to my channel. Iran, what the law of the sea says about detaining foreign ships in transit. Within the British ship, the Stena Impero now detained in an Iranian port under investigation for its alleged transgressions against navigation regulation in the Strait of Hormuz. There are several legally curious aspects to this affair. So far, the Iranian authorities have given only scant detail of what the unlawful action of the UK-flagged ship were that caused them to detain it. The information seems contradictory. Some reports say the ship collided with a fishing vessel. Others that the chain of course ordered by Iran's Revolutionary Guard vessel was for security reasons. But explanations are wanting as pretext for interfering with merchant shipping in strait used for international navigation during peacetime. Keeping transit flowing. The legal regime for such trades in Part 3 of the UN Convention on the Law of the Sea or UNCLOS is designed precisely in order to keep open such vital choke points for seaborne trade. Under Article 44, states bordering strait may not hamper transit through them, nor suspend passage for any reason. Article 39 obliges ships exercising the right of transit to proceed without delay through the strait, refraining from any threat or use of force against state bordering the strait. In addition, Article 41 requires ships in transit to respect applicable sea lanes and traffic separation schemes. Such a scheme does exist in the Strait of Hormuz, adopted by International Maritime Organization, which direct westbound traffic within the strait through Iranian territorial waters. It's not clear where, in relation to the outer limit of Iran's territorial sea, the Stena Impero was when the Iranian action took place. But Iran is not alleging the ship had no right to be where it was. Ships in transit must also comply with generally accepted international regulations, procedures, and practices for safety at sea, including the 1972 International Regulations for preventing collisions at sea and for preventing pollutions. Iran signed UNCLOS, but unlike the UK, never went on to ratify it. This raises questions as to whether Iran is even bound by anything in the treaty if the matter were offered to go before an international court or tribunal. It would be in the UK's interest to argue that the Part 3 regime, negotiated nearly 40 years ago, has also come to represent the customary international law on passage through such strait, applicable to all states. This argument would stand a reasonable chance of succeeding. The claim by the owners of the Stena Impero that the ship was in international waters needs to be approached with skepticism. In the narrowest part of the strait to such waters exists, all of it is within the territorial sea of either Iran or the other coastal state or Oman. Still, there is nothing in Part 3 that allows a coastal state to intervene and order a vessel into port. The purpose of the legal regime is to keep traffic moving and to deal afterward with the local consequences of any navigational incident. An act of retaliation. Iran threatened to retaliate against the UK for the detention in Gibraltar in early July of the Grace 1, a tanker with a cargo of Iranian oil allegedly bound for a Syrian port contrary to EU sanctions. It's conceivable that Iran regarded its act against the Stena Impero as authorized by the legal doctrine of countermeasures, but this is a rather long bow to draw. Unlike domestic legal systems that normally frown on those who take the law into their own hands, in international law there is no policy force. And to fill the gap, the doctrine of countermeasures permits a limited degree of direct enforcement of obligations owed by one state to another, under a number of conditions. The most straightforward of this is proportionality, detention of one ship in response to that of another. But any defense based on countermeasures is always risky. The state advancing it is effectively admitting that its action would otherwise be unlawful, and it depends on the accusation of prior breach by the other state being legally correct. Yet, it's less than obvious that the UK's detention of the Grace did infringe Iran's right. It may not even be an Iranian ship. It was removed by Panama from its shipping register in late May, alongside several others on suspicion of breaching sanctions, unless Iran has since taken the Grace One onto its own register, of which there is no evidence to date. Its only clear link with the Grace One is property in the cargo of petroleum, limiting Iran's ability to argue its retaliation in taking the Stena Impero was a countermeasure, and it certainly isn't, as Iran has claimed, an act of piracy. Piracy, by the definition in Article 101 of UNCLOS, can be committed only beyond the territorial sea and the Strait of Gibraltar, like the Strait of Hormuz. Is narrow enough to be completely overlapped by the territorial seas of the state on either side of it. It can also only be committed for private ends by the crew or the passengers of private ships or aircraft. So, the only way piracy can be committed by a warship or state-operated helicopter is if the crew has mutinied and is engaged in plunder for profit. Clearly not the case with either of the detained ships. State piracy, the UK's a wholly overheated countercharge, doesn't exist either. Okay, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe this channel. See you in the next video, and bye bye.